Well, you can go back and look at the transcript if you want. If he wants some representation now, he can either have a court-appointed a lawyer, or he can hire a lawyer on his own. But at this juncture, I'm not inclined. You know, I get so. I told him this back then, that he needs to go get the rules. I gave him an opportunity to read the rules of procedure. Have we had this discussion before?
Yeah, I'm here on behalf of the defendant, Jamil Lockhart, and they're making a special appearance.
All right. Well, you got to make your special appearance to the Wayne County Jail. I told you that the last time.
Yeah, so I filed a notice of removal for all of these cases because I don't believe that this court is capable of acting in an unbiased way.
Robinson, we took care of your Latham, so I marked the file as you appeared for Latham and Corporal Spidell. So you're all set. Be safe out there, all right? Included, I still see Mr. Lockhart here. I don't know what else to do. What else you can do for him, Mrs. Harris? She continues to disobey the court order. Just continues to do so.
Your Honor, I dare not say. Well, I don't know. I don't think that it's an intentional. Oh, I can't say that.
Wait a minute.
I don't think. I'm gonna take that back. I'm gonna take that back. I think he has good intentions. I think he now has a better understanding of everything that is taking place.
Hey guys, and welcome to today's video. What you're about to watch is a textbook example of how courtroom patience slowly turns into courtroom consequences. This case isn't about violent crime or serious harm, it's about defiance, legal fantasy, and a refusal to follow basic court procedure. You'll see a judge who gives repeated chances, explains the rules clearly, and even tolerates disruption far longer than most courts would. But you'll also see how repeatedly rejecting reality eventually leads to a hard stop. Stay with us, because this escalates fast.
All of these matters, we've had the discussion. We asked for leniency and mercy from the court. I understand if the condition is that he still has to do 30 days in the Wayne County Jail, although we would ask if the court would reconsider that sentence now that he has taken the time to actually listen to advice of counsel and be made fully aware of how he should present himself in court. I know that it's his intention to resolve these matters without any further court appearances or draining any further resources or delaying the process anymore. And I know that the court doesn't want to delay the process any further. I understand his behavior is what put us in this position as of right now, but we're just hoping to resolve today if the court will allow.
I'm not moved. I gave him ample, this is a 27 plus, maybe 30 plus minute video. I gave him ample opportunity. And I'm not moved.
I mean, Your Honor, in that video, I did apologize to you for, I guess.
You apologize after you got the 30 days.
Right here is where things start to go sideways. The defendant claims a special appearance, a common sovereign citizen tactic meant to deny the court's authority while still participating in proceedings. Courts don't work that way. You can't show up, file motions, speak on the record, and then claim the judge has no jurisdiction over you. The judge already addressed this before, which makes the repetition even more damaging. At this point, the court isn't confused. The court is documenting continued non-compliance, and that matters later.
I'm giving you an opportunity at that day to speak with the lawyer. You refuse that. You refuse all the opportunities I've given you. And you came in here another time a couple of months ago, and I told you we weren't going to hear it then. You got to go report to the Wayne County Jail. So you've had ample opportunity.
you'd have me go to jail.
No, on behalf of Jamil Lockhart, I do understand that, and I know the court he may hear this often, but he does have a family that he supports. It would be a great hardship on his family, his resources, and his sense of economy in terms of his job if he would have to submit himself to 30 days in the Wayne County Jail. I understand that the court is not inclined to change that.
I didn't just give him the 30 days on the, he should have thought about that when I was asking him. I let him speak when I was asking him to not try to overtalk the court. Let me give him an opportunity to speak. He continued to disobey that. He should have thought about that then. There's a whole lot of people up in the penitentiary that have families that they take care of, and he's not going to the penitentiary. It's just county jail. So I'm just not moved.
What this court?
Notice the judge's tone here. It's calm, measured, and deliberate. This isn't anger, this is frustration built over time. Contempt doesn't come from one mistake, it comes from repeated refusals to follow instructions. The court has already warned the defendant, already explained expectations, and already allowed extensive time to speak. When the judge mentions continued disobedience, that's the legal foundation for consequences. Judges don't punish beliefs, they punish behavior that disrupts the court's ability to function.
He has presented himself to the court today.
Okay, you want to take we'll take off the warrant, we'll give him a pretrial date, and then he can go do his 30 days, and he can tell the sheriff in there that what his next court date is, and they can, or somebody can rid him out then. City of Detroit versus Jamil Amir Lockhart, case numbers SP 1247989, counts 1, 2, and 3. State of Michigan. Now the laws just don't apply to him. State of Michigan versus Jamil Amir Lockhart, case number SX 378-29611. Appearance for the record, please.
Sherika Harris, on behalf of Jamil Lockhart, sir, could you state the name of the person that you are representing on the record, please, or that you identify, please?
So my name is Jamil Lockhart.
For purposes of arraignment, Your Honor, my client would stand mute, but we would ask if the court could read the charges, please and thank you, so that Mr. Lockhart is.
This is a strategic pivot by defense counsel, asking for mercy based on claimed understanding and remorse. And to be fair, judges do consider that when it's supported by action. But words alone don't erase months or years of defiance. The judge makes it clear, apologies after consequences don't carry much weight, especially when prior opportunities were ignored. Courts value accountability demonstrated through compliance, not just statements of regret. This moment shows the difference between asking for mercy and earning it.
SP 1247989, counts 1, unregistered, untitled, maximum possible penalty 93 days in jail and/or $5 fines. SP 2 of that is an improper license, maximum possible penalty 93 days in jail and/or $5 fines. Count 3 of that is a no insurance, maximum possible penalty 93 days in jail and/or $5 fine. And SX 378-29611, that's an improper license, maximum possible penalty 93 days in jail and/or $5 in fines. He's got an expired plate that's in default that I'm not going to set aside. He owes $174 on that. As for purposes of arraignment counsel.
Again, Your Honor, Jamil Lockhart would stand mute. Ask that the court would enter a not guilty plea at this time on his behalf. Mr. Lockhart, I hope you're recalling these are all things that we discussed in the breakout room. I told you how the process works.
All right, I'll enter a not guilty plea on his behalf. I'll give him a $0 bond. We'll set a pretrial in the matter for 9/22/2023 at 8:30 a.m.
Here comes an emotional appeal, family hardship. And while that argument is human, it's not legally decisive. The judge responds with a hard truth. Many people in jail have families who depend on them. That alone doesn't excuse contempt. Importantly, the judge clarifies this is county jail, not prison, reinforcing proportionality. This isn't about cruelty, it's about enforcing court authority. The judge is drawing a line. Consequences exist even when they're inconvenient or personally difficult.
He didn't want an attorney. And I guess you have gotten through to him a little bit. He changed it. He came in here hearing on behalf of the person, Jameer Lockhart. And then when you asked him to state his name, he came and he indicated that he was Jameer Lockhart now. So I don't know what he like I say.
I mean, if I could speak a little bit here. I don't know, Your Honor, I'm not a criminal. I just want to handle this, get this over with.
I didn't say you were a criminal, sir. I didn't listen.
No, I know you didn't.
I didn't say you were a criminal. As it stands now, these are allegations. So until there's an adjudication of either guilt or not guilt, that'll determine, whether you're a criminal or not. So I don't know. You got these allegations out here. So I didn't make that comment. You were a criminal.
Right. No, I'm not saying that you did. But I just want to handle this and, put this to rest. At this point, I feel like it's taken up too much of my time, too much of, your time, I'm sure. And,
this is what I do every day, sir.
Once again, the name distinction resurfaces: person versus individual, spelling variations, identity labels. Courts see this constantly, and it never works. The judge's response is telling. He's no longer engaging with the semantics. When a judge stops debating and starts ruling, the window for persuasion is closed. Identity arguments don't erase court jurisdiction, warrants, or prior findings. At this stage, continuing them only reinforces the court's view that the defendant refuses to operate within legal reality.
Last year, over a year and a half ago.
Mm-hmm. Okay. Well, yeah, I mean, I just want to resolve this. Whatever I owe for those offenses, I'm willing to pay, and it'll be done with this situation. I truthfully don't think it's your, mission to put people in jail that have not harmed anybody or committed any offense against, any actual live human being. I'm only guilty of speaking out of turn. And, I should have handled this differently. I can see that now, but I really just want to get this whole situation rectified, and whatever the charges are that I need to pay, I'm willing to do that, and I'll put this to rest.
I'll let him speak. Next pretrial date is September 22nd.
Yeah,
Well,
based on the statements.
That being said, I don't think, based on everything that has happened, our history, the claim in federal court that I have against you, Michigan judicial tenure complaints that I have against you, I think you have a duty to recuse yourself from any of my cases.
I haven't been privy to any judicial tenure complaint. My first duty is a duty to sit, and I feel that I
put it in your mailbox.
Okay, well, all right. Well, the Judicial Tenure Commission will have to come, and I'll have to respond to them accordingly if they present something to me.
Okay.
All right. Have a great day, sir. Next court date, 9/22. You're still expected to turn yourself into the Wayne County Jail.
Well, Your Honor, I would ask one final argument. I understand that he may have indicated he did not want an attorney to represent him. Jail time is a very harsh penalty. And I know that the court didn't just immediately come to that decision. I would ask if the court would consider some of the things that were stated on the record in terms of he now has a better understanding. He is remorseful of how things played out. And I would ask if the court would issue a monetary fine for the contempt rather than jail. If the court, please.
And he's got a proceeding in federal court against him. So where is it, you know, where is this,
I'm simply trying to protect.
Your Honor, but again, Your Honor, Mr. Lockhart, on behalf of Mr. Lockhart, stop. What I'm saying, the court has to understand the fact that a lot of these things came into play before today. So if in fact there was something filed, it was before today, before having a better understanding of how the process works, how to conduct oneself in court, and that one is held to the same standards as an attorney. I would ask if the court would consider converting that jail term into a monetary fine.
Not at this point. At this point.
Your Honor, I only have a federal claim against you as a means to try to keep myself out of jail, right? It's not something that I want to do, you know?
You can take any action. You can take any action under the law that you choose to, sir. I haven't prevented you or even tried to even attempt to prevent you, and I can't prevent you from doing it.
I don't want to do that. I just want to handle this, pay whatever I need to pay, and move on.
So again, advocating on behalf of
needs to be sitting in jail. I'm an upstanding individual. I have a lot of people that depend on me, and I haven't harmed anyone, and I never would.
Understood. Thank you for that allocation. But on behalf of defense would now move to ask if the court would allow a hearing on the contempt proceedings.
That hearing has sailed. He has been gone. He has 30 days for the hearing. Procedurally, that has sailed a long time ago.
So he already had a hearing on it?
No, we asked him, offered a hearing on that. We offered him an attorney on that before we entered into found him in contempt. We offered him to speak with the lawyer on that day. He chose not to. It's been over, I would say, quite frankly, a year at least. The motion he was going to file a motion by 5/27/2022. It's been a long time. Those ships have sailed.
But Your Honor, arguably he didn't have the assistance of counsel. So I would ask, did we go through all of the steps for him to waive his right to counsel in that type of proceeding?
Well, you can go back and look at the transcript. If he wants some representation now, he can either have a court-appointed a lawyer, or he can hire a lawyer on his own. But at this juncture, I'm not inclined,